Today I'm going to try and take you through three elements. One is to say what was the context in Australia for the shared parenting, or what's called in Australia the pro-contact reforms of 2006. What was the social context, the legal context? And then what were the reforms, secondly? And then finally, what were some of the consequences of those reforms as far as Australia is concerned? So those are three areas I'll take you through. Australia is very fortunate to have a huge amount of money invested in research, and it seems just from the comments I've had from friends here that Canada, for lots of good reasons, doesn't have that same kind of research background. So the Family Law Council, which I was involved in, is a body set up under the Family Law Act to research the effect of legislative reforms in the area of family law. And then there is an amazing body called the Australian Institute of Family Studies. And that body has had, it's also set up under the Family Law Act, so it's a statutory body, can't be destroyed except by having its funding cut. And so they put out this remarkable report, evaluation of the 2006 reforms. That book cost $6 million to prepare. So a team of researchers, very respected researchers, were paid to put together this outcomes research. This research was triggered by the murder of a number of young children by parents, and government is always motivated by the murder of young children, and that's the reality of politics. And so they were nervous, not because of the reforms, but rather because of the publicity that came from the murder of children, and led to a lot of funding of research. Are the reforms problematic? Are they not? So this is a great report. Like most reports, nobody's read it. So it's one of the ironies of research in this area. So I'll take you through those three areas. Does anyone not have a copy of the paper in front of them? You'll need this in front of you because this is a case of stem lies and statistics. So could you make sure you've got that there? All right, so there's quite a bit of introduction in relation to context. So this is a version of history. It's a reconstruction of history. All history is reconstructed, so I'm doing a reconstruction. And you should treat it with a degree of skepticism whenever somebody comes along and tells you this is what has happened. It also enters the very dangerous area of cause and effect. So in Australia in 1976, the divorce rate tripled. There was also an eclipse of the moon in 1976. So did the divorce rate cause the eclipse, or did the eclipse cause the divorce rate to escalate? Or was there no relationship at all? So this is one of the dilemmas of discussing being a human being, is cause and effect, correlation, and do they have any relationship which is worthwhile to discuss. And so I'll make some comments about that. You should again treat this all with a degree of skepticism because we are dealing with a measurement of human behavior, and that is always going to be problematic. As Wanda said, I was in a privileged position to observe this, and I was advising the Federal Attorney General who had not exactly open ears to many of the feedbacks because there were no votes in this until the children started to be killed. So as I give you stats, and this paper has got stats in, you should ask questions about the stats, but know that whenever you do a statistical study, you are creating a snapshot. So the person goes in with a questionnaire. 28,000 people were interviewed for this report. It's probably the largest report in the world following such a reform. And so all statistics are problematic because as you interview people and say, what are your current parenting arrangements? Good question. They will give you different versions. Dad and mum will give you different versions because people see the world differently. And then in 4 weeks' time, it'll have changed. So statistics are going to be problematic, and you'll see that some of them are fuzzy, but as far as studies go, this is a pretty good series of studies. Note that they were paid by the government, therefore you should be suspicious. Are they giving the government what they want to hear? And then you ask what kind of independent studies were done subsequently by people who were not being paid by the government. Did they confirm this or not? So in Australia, there's this little journal Family Studies, which followed up with a number of reports on this, what's called the AIFS report, AIFS, Australian Institute of Family Studies. So, so snapshots and careful of stats. Next kind of qualification is I'm what's called in Australia a man from Mars. So Australians are very skeptical because we have a progression of people from California and Canada coming to us telling us how wonderful this program they've instituted in their particular country. Sweden is another one where we have a traffic of people saying you should institute spousal maintenance in your country because it works so well in Canada, this kind of thing. You should be skeptical about a man from Mars because when we arrive, could be a woman from Mars too, when we arrive, we are trying to translate a law that works or a system that works in one culture and say maybe it works in another. So be careful of triumphalism that comes from other countries about how well our system worked. It rarely works that well, and so just beware of me. All right, I'll give you some of the other context. Is at the same time these reforms took place, Australia, the government spent another gazillion dollars on setting up 65 mediation centres across Australia. This is a dream for many countries. They say, how did you afford this? Still don't know. The taxpayer paid for it. So these centres are places where people go to and in order to deal with challenges with children, with separating families, and get free mediation up to a certain point, and then if they want to continue the mediation, they have to start paying based on income. Those centres were swamped with activity. So one of the ironies of this, which I won't really go into, is when you set up helping institutions, they will always be swamped with clients. If they are, because outside these nice walls of this university, there are many needy people, and they will go to any institution, whether it's called mediation, psychotherapy, a drop-in centre. If it's semi-competent, it will be swamped with clients because clients will go to the places where they get free and competent services. So this was a huge disappointment to the Attorney General because they were hoping that if they set up new helping centres, activity in the courts would diminish. Not at all. Judges are busier than ever, not with contested hearings. We'll come back to that. So all the government finds they're doing is paying out more and more for courts and for helping centres. So helping centres pick up the lost and the lonely. They don't necessarily relieve another set of helping centres like courts. So those are some kind of preliminary comments. All right, and back to now spread heresy for you at law school. Studying litigated cases is a fairly useless activity. Because statistically, so few people get involved in litigation. And if they do, they probably represent an abnormal group of society. So what are you studying when you study litigated cases? Answer, you're studying data that is accessible, not data that is important. That's very important in this field. You're studying data that's accessible and not that which is important. One of the great critiques of lawyering and legal research, and I've been involved in that kind of research a lot as well. So I'll come back to that theme at certain points. All right, more on context, having told you not to trust anything I say. You will need a pen to write comments on this as we go through. You should have 1,000 questions. If you don't have questions, you're probably not engaged in this topic. So I won't be able to answer many of your questions, but I'll give you impressions sometimes or just say, I don't know. All right, so context. If some of these comments sometimes seem cynical, I don't see myself as cynical. I see myself as harshly realistic in terms of how systems work. I'll make a cross-cultural comment now. I found sometimes with Canadians, because maybe of the politeness of your culture, and I'm married to a Canadian too, that, and I live in Vancouver now, moved I'm a permanent resident. So I make the comment that I find here sometimes Canadians are not willing to say the hard thing. It's as though it's too offensive to say that the courts don't work, that the system is broken down. In Australia, we delight in saying things are broken down. Okay, so here we go. This is how it has worked, and this, if you write on the top of this leads to reform fatigue. The Australian family law system is looked upon as a model for the rest of the world. We have lots of wandering gurus floating through, looking at studying the system, lots of money, lots of specialised courts. So this is how it goes for 40 years. The consumers complain about what is happening in the system, in social security, in mediation, in the courts, in the lawyers' offices. They complain. They go to the press, so it becomes sensationalist. Either fathers complaining, children complaining, mothers complaining, the government complaining because they're paying out too much in social security. They phone the politicians. So if you talk to the backbenchers, what are the most phone calls in Australia that they get? Answer, family law complaints. Family law complaints. Drives them crazy. And so when you are a bureaucrat and you have complaints, what do? You strike a committee. You get rid of the complainants into a committee. So the politicians get exhausted in the backbench with all the phone calls. They form a reform committee. The reform committee spends about 2 years meeting, having submissions, travelling the country. That's what the Family Law Council, that's what we do. We write lots of things. It's expensive or very, very expensive. And after that, they write a long report, which no one reads. Okay, that's very important you understand that. People in data avalanche don't read stuff anymore. They are exhausted by data overload. The long report leads to a reaction. People say, oh but, you don't understand, this is outrageous. So feedback comes crashing through with a lot of anxiety that things are going to change, and human beings do not like change. We want to hold on to the status quo. And then most of those complaints are ignored, and an act comes into place. It's incomprehensible, it uses long language, it's drafted by parliamentary draftsmen who, on the night that the bill was about to come into effect, were cutting and pasting, lobbying groups were phoning. So it's those of you, the old adage of law reformers, those of you who like sausages and laws should never see either being made. Very, very important proposition, okay, to understand the world of rationality is not prevailing in law reform. So it takes 2 years of active involvement of lawyers, counsellors, lobby groups. What the hell does this mean? You're trying to demystify a new act. The Family Law Act in Australia is over 1,000 pages long. That's the Family Law Act. It's been amended 80 times since it came into effect in the 5th of January 1976. So 2 years to demystify. So you can imagine how much the CLE empires make, continuing legal education. We have one seminar after another. What does Section 66C mean? I don't know, but here's a guru who'll tell you what it means or what it might mean. So a huge amount of expense. For the clients, this is a very troubling time, because you go to a lawyer, and if the lawyer's any good, and I worked in a highly specialised family law firm, you say to your clients, I don't know what it means. I got no idea. I thought I knew what the last round of reforms meant, but I got it wrong then too, so I don't know what it means. This is what it could mean, but basically don't go near the court system, settle, because the judges don't know what it means either. So we go around, and what happens is some lawyers, very good lawyers, give up legal practice because they have reform fatigue, and they say, I can't keep up with all these changes. So you have bureaucratic burnout in the courts too, because people are contacting the courts saying, what does this mean? They're contacting help centres. So skilled helpers burn out, and we engage in a lot of self-protection. We write letters saying, I don't know what this means, but this is my best advice at the moment based upon what I know. The media feeds on, once again, the extremes of people who are having bad experiences in the system. Whatever the system is, people have bad experiences, and they report that they got no money, that they went bankrupt, that someone didn't pay, that the judges were unsympathetic, that the mediators don't know what they're talking about, that they got pressured into settlements. So this leads to a lot more sensationalism, consumer complaints, and guess what? The cycle starts again. So this is an eternal cycle in Australia, and people in the helping professions find it quite a challenge to stay above all of this and to keep motivated. I'm not sure that Canada has quite the same pace of change in that cycle. It probably has a slower version of it. Next, this is all context. This is very important to get context. In Australia, this on page 3 of your handout, you have what might be called the traditional court system: due process, considered facts, considered evidence, apply the rules, judgments, enforce judgments. Okay, these traditional courts just have decades of criticism, like law schools, decades, centuries of criticism. And the criticisms you should know about, because as a professional helping people, you say, yeah, we can have brain surgery, but here are the downsides and here are the upsides of brain surgery. So cost, delay, uncertainty, on and on and on. So this is the cycle that occurs. The criticism emerges from gossip, from the mouths of lawyers, from the mouths of mediators, from the mouths of the public. Did you hear what happened? And the media, of course, capitalizing on this fear of change, fear of uncertainty. So historically, those of you who studied law and equity, that led to the equity courts, okay? Led to the Lord Chancellor saying, frozen system, the legal system doesn't work, come to me, I'll give you justice. That led in other settings to arbitration. So in many places in the world, the system was broken, so you employ private arbitrators. So in Australia, for a while, after 1976, there was a lot of money around for what's called state legal aid. So many young lawyers learnt their trade, being paid for by the government to act for people, to give them advice, to help them settle. But like most countries, and Canada is high on this list, is legal aid just crashes. Or you have constitutional rulings which bleeds all the legal aid back towards criminal law, leaving family law in the wilderness and families in the wilderness. So that happened in Australia. Constant public inquiries with wonder stories and horror stories, people trying to effect change by sensationalism. So the courts respond with case management, this a managerial movement of saying, we will begin to measure how long hearings take, how many filings occur, how many people we will allow to go to brain surgery. The rest we will break their arms and make them stay out of the system. So number crunches emerge into the system called the justice system, and a lot of delegation. So good managers delegate. So you have emerged in Australia what's called the tribunal movement, which exists in Canada, but I haven't heard called that name. You create quasi-courts. Less due process, less expense, sometimes lawyer-free. Lawyers are not allowed in the zone at all. On the theory that lawyers make things worse, that theory is not clear. But what's interesting about these people is they are obsessed with statistics, because a tribunal can be closed down if a politician says you are not having a success rate. So this new brand of adjudication is run by managers who are excellent with statistics, putting the courts to shame. The courts don't have the statistics to demonstrate performance levels, settlement levels, and so on. But the tribunal movement has multiple tribunals. One for oyster leases, another for taxi licenses, another for child support, another for children's supervision during visitations. So you have a version of this in the Aboriginal residential schools compensation bodies. They're really what we would call tribunals. They have abbreviated due process, El Cheapo, a lot of phone calls to do it. So you have a version. So these tribunals start off with multiple tribunals, then the bean counters come in and say, no, we want to amalgamate. So it's a standard business practice, isn't it? When you have branch offices, you bring the oyster leases, the child support, and the taxi drivers' licenses tribunals all together in order to effect savings, the big cry of politicians. So they're combined, they don't stay multiple. So initially these have the mantra of being fast, inexpensive, and accessible to the public. That's the mantra which drives these new access to justice tribunals. But here is one of the ironies, conflict of interest. Guess who supervises the tribunals? The traditional court system. So one of the competitors is supervising the new competitors. This is what happened in the arbitration movement as well, and in equity, though equity managed to stay independent enough and avoid supervision. So you begin to have reactions coming from the courts saying the tribunals do not have enough due process. They didn't listen to the mum for long enough. They didn't listen to the dad for long enough. They didn't get a 4-page document from the social worker. So a lot of phone calls complaining about tribunals, which is different than complaining about a judge, because you can't sack a judge. A judge is a lifelong appointment. So here we have the dilemma of new tribunals. They are not sufficiently independent in some people's eyes. So they slowly become slow, expensive, and formal. The reverse of their mantra: fast, inexpensive, informal, because they are scared of supervision and of losing their jobs, which is natural. All of us are scared of that. So they slow down. Exactly what happened to arbitration. Arbitration is more court-like than court, because the arbitrators in many places got supervised to death. So nevertheless, because they are trying to survive, these tribunals have much better research base than the courts, and they're much more impressive to study. So the child support tribunals in Australia are awesome in terms of the stats. So most of the research about child time is done via the child support empire, because they are statistically obsessed. They know that if they can't prove they're efficient, they're going to have their budget cut. So they are keeping stats on how many overnights a year each child in Australia is spending in each household. And their stats are great. Their stats are amazing. Okay, so then going around the circle, you have voluntary mediation gets instituted in the late 70s, and that has a mini boom. That was my world. Then you have mandatory mediation and med-arbs. Some of these have research attached to them, and then you have the online advice movement. In Australia, the cycle goes into how can we abbreviate this, how can we make it cheaper, how can we make it more accessible. So online systems which are accessible to certain class of people who may not have used some of these other systems to get advice, to get information. So a big industry of, and that's, I think, is also present in Canada from what I've been able to see. So all this change cycle is driven by dollars. Dollar is king. Money is king. Don't talk about child welfare, you talk about dollars. Dollars is king, okay? Children, 80% of change is driven by dollars, 20% by being interested in kids. And electoral popularity. How many votes are in this change? How many votes are in this change? And the answer generally is none until a child's killed. So you go to the Attorney General, and with all these wonderful proposals, they're not interested because in Cabinet he's been told to cut expenditure on every institution by 10%, by 20%. So you go back and say, here's a way of improving which involves expenditure. Answer, not interested. He glazes over. He starts to count the nails in the roof. So this is the interesting thing, is at what point does a Charter of Rights or a supervisory court say, I want to rewind the clock? The system has changed too much towards mediation, no due process, little due process, cutting expense. You try and rewind the clock to say more due process, go back around the circle, or do the courts say, oh no, this is okay for us to stay around here? So that's the context, and it's a fascinating context to watch. I suppose any questions at this stage? I'm still at context. Okay, no questions, it's all clear. Everything is clear, okay. So this is a great study, everyone. This is Mark Galanta, the great legal sociologist, asking the question, why, since the mid-1980s, has there been a dive in every Western country in contested litigation? Right? So the phrase is full-blown cases. That's the phrase he uses. So Hollywood tells us there's lots of litigation. Wrong. The statistics are overwhelming in every Western country. Full-blown trials have been crashing on the graph since the mid-1980s. There are some minor exceptions, such as prisoners' rights litigation, where prisoners are arguing they should have access to libraries and this kind of thing, but they're minor aberrations. So this is called the decline of trials, the disappearance of the trial movement, and there are some of the reasons why this is happening. So that's one of the challenges also of why study litigation when it's dealing with a smaller and smaller group of people. Why study full-blown litigation? Judges, when they see these studies, they cannot believe it because judges are working harder and harder. Their lives are more and more stressed, and that is for different reasons than full-blown trials. They are now managerial judges. They're being told they have to get through a lot of cases and get rid of them out of the list, not because of full-blown trials, just to get rid of them, because the system cannot cope. Fewer and fewer judges managing more and more stuff underneath the full-blown trial. Okay, some statistical patterns, which are then, we're all context here. In Canada and Australia, both have about a 40% divorce rate, and then have a hidden, what you call common law marriages, we call de facto relationships, large numbers of those combining, separating, which would take that so-called divorce rate much, much higher. In Australia, half of the people divorcing have dependent children, and so of the 50,000 divorces, about 25,000 couples with dependent children, which amounts to about 50,000 children entering the system every year from ceremonial marriages. A new population, a new group in the python are coming in. And if you add to them maybe another 5,000 children out of de facto relationships separating, but the stats on those are very wobbly. Okay, so here are just some thoughts. There are 3 stages of marital relationships you can argue. There is young experimental relationships with probably an 80% separation rate. There are so-called midlife, you see midlife's pretty extended there, to childbearing relationships, a 40% separation rate, and then this new, again, the baby boomers trying to dominate the scene. Older life companionship relationships from 60 to 85 years with an increasing separation rate. So the grey divorces are on the rise statistically. Other dual income marriages, which would be absolutely normal for everyone in this room, it's still, when you look at the trends are upwards here and a different pattern where women are returning to paid work soon after childbirth. They're doing this for reasons of social reasons, foot in the market, earning money to pay for your expensive house in Vancouver. Males are increasing as the homemaker parent role, so there's the graph going up. It's going up pretty slowly. And there are flexible careers. People go in and out of the workforce. They move from different city to city. And there's a high demand for childcare assistance, high demand, which is kind of middle upper class can afford, and others just muddle through. Female employment is climbing, particularly in the fields of education, health, and administration. So they're female dominated. Those are also the long-term employment available there, whereas female majority in university study, male employment is decreasing because males tended to be in these fields: retail, manufacturing, construction, and auto industries. Those industries are in Canada, Australia, are in trouble. They may have occasional booms, but they're in trouble. Global and female paid work competition is increasing for males. You've seen that in the law firms, the outsourcing to India. Research is done in India at probably a tenth of the cost. It's done by a local person. So outsourcing all the work of Richard Susskind. Those of you who are interested in following us up, just Google Richard Susskind, Susskind. You must read or just watch some of his interviews to give you, he's the prophet of the future in terms of legal work. There's a looming austerity and poverty crisis, page 6, because of the what's called the extra 20 years of life in both countries. People are living for longer. There will be poor health and a need for money, and Canada and Australia saying we are not prepared for this. We just put our hands over our eyes and hope for the best. Tax income is in the business of the state is a business, income is declining. Tax is going down, 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 expenses are going up, up, up. Failed pension planning in both countries, though much bigger failure in Canada than in Australia. Increased dependency on social welfare drives the politicians crazy. How come so many people are depending on the state? Court systems, I've added a few here, are overwhelmed in both countries, stressed and overwhelmed. For interesting reasons, remember, not full-blown trials, not full-blown trials. Don't let Hollywood or the newspapers fool you. There's increased do-it-yourself litigants. So these are called self-represented in Canada. They're called pro se, when in doubt speak Latin, in the United States. And there is an increased openness about mental illness. Probably mental illness has always been there, but there's increased willingness to discuss that in society, in the media, that this is a major factor in modern life. So there's some context, more context now, because this is extremely important for consequences. So what is the law? Page 7. One assumes the law is known. It's the rules in one of these great big books. Wrong, wrong, wrong. So here is one version of the law. So this is what you as a lawyer, what I as a lawyer talk to my clients. I guess a prediction on the range of outcomes which are likely to happen if you continue towards a due process mediation, or if you continue towards a due process negotiation, or even to the door of the court. The law could be a statistical pattern which goes beyond the anecdotes that I tell in my law office and you tell, to a statistical pattern of what has been happening. This is what has been happening in Australian society. And then you can have the ought. This ought to have happened. Children ought not to have been left in high conflict families. Children ought not to have been left in the care of a person who is a drug addict or is alcoholic. But that's an ought proposition, and these first two are is. All right, so here are the versions of law that you need to think about very carefully. You will be bombarded with these as a family lawyer, as a succession lawyer, as an employment lawyer, as a tort lawyer. And you might want to write little definitions next to this. Folklore or gossip law is what people chat about on the street. Oh, did you hear there's a new law around? There's a new law around. Dads have to pay 30% of their income in child support. Gossip, wrong. Gossip, wrong. Okay? Did you hear there's a new law around? Children should spend approximately equal time with their mum and dad. Wrong, wrong. Gossip law is the most important form of law for settling disputes in family law. Gossip law is the key because most people don't go anywhere near lawyers. The majority don't go anywhere near lawyers. They settle based upon all kinds of pressures. Right? Street law is a Hobbesian version of gossip law. This is sometimes called pub law. It's very important. It's what you deal with as a family law practitioner all the time. Is that the discussion of how to win or manipulate the other people. Well, just accuse them of domestic violence. See what happens then. When they ask for the documents, just lose the emails. Whenever you send the kids round for visitation, make sure they've got a tape recorder in their school case. So pub law is about fear, force and fraud, how you manipulate the other side to gain strategic advantage. Local law, this is much under research, so notice here how we in law school completely fail. We have for 100 years. It's not a failing of this law school, it's every law school. We don't study this stuff. We study books in the library and do internet searches. This is the work of psychologists and particularly anthropologists and sociologists. Local law is the differences in how the law is applied around Australia and then Canada. What are the going rates in Perth? What are the going rates in Wagga Wagga? So Aboriginal language, plural of crows. When you want to say plural, you say it twice. Wagga Wagga, the place of many crows. That's just an aside. So local law, extremely important. This is not how it's done in Toronto. This is not how it's done in Halifax. So where are the studies to show you that the systems are different in each part of the country? Extremely important to give accurate advice to people. Next, settlement law. It's called the going rate. All of those people who work in tort areas know about this. What's the going rate for a smashed knee? Oh, between $80,000 and $120,000. Great. So what's the going rate for child time? Far more important than the law of the books, far more important than the judges. The going rate is extremely important. So the major effect of the law reforms in Australia was that in 2006 was the going rate, 80-20, moved to 70-30. Okay, the going rate was the non-residential parent gets 20% of the overnights. The reforms came through, studying what was the going rate, moved to 70-30. They get 30% of the overnights. Next form of law, law office advice law. Law office law, again, is way more important than the law of the courts, the law of the judges, way more important. Law office law is what lawyers say to their clients. The client says, oh, what am I entitled to? The lawyer goes, blah, 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 blah. That's the law. That's the law. Why? Less than 10% of people get anywhere near a court. The blah, blah becomes the law. And if it's wrong, it's still a law. People still take note of it and still do something about it. So how much do we study the law of the law office? Answer, very little. Very difficult to study it because of confidentiality, but I think there's a footnote to the great 1986 article by Sarrett and Felsteiner on the key study of law of the law office, and they managed to get inside of multiple law offices and listen to lawyers giving advice. It's a 1986 Law and Society Journal, something like that. It's footnoted somewhere in here. That's one of the great Shakespearean articles around, because it opens this door that is so difficult to study. Next, client practices. This is the law. Forget about the law. What do clients do? What do the majority of clients do? That becomes the law. Right, so this is, Galanter has raised this wonderful reverse. We bargain in the shadow of the law. He says that's true, but the adjudicators adjudicate in the shadow of the bargains. Very important, flipping the coin. Adjudication in the shadow. The judges ask, what's the going rate? What are people doing? What are the average Australians doing with their kids? And that becomes influential on what the judges order. All right, so it's two-way street. And then finally, we get to what we study at law school, trial judge law, appellate judge law, and organised law. So this is people like me as an academic, textbook law, trying to systematise 7 and 8. But 1 to 6 are the most important forms of law, particularly in family law, succession law, employment law, the most important forms of law, but they're difficult to study. So this is where these studies are breathtaking, because they suddenly begin to open the door to sum of 1 to 6. 28,000 interviews, of separated couples, their lawyers, their mediators, you start to suddenly get a new view of what's going on. Questions? We're still on context? All right, page 7, the next thing to be careful of is terminology. Be very careful of comparative studies. You go to California, say, what does custody mean? They give you a definition, say, well, it doesn't mean that in Australia. You go to Louisiana and say, what does guardianship mean? Well, it doesn't mean that in Australia. So beware of the word custody, beware of the word residence. They all mean different things from one jurisdiction to another. So a fatal flaw of law reformers is to go and look at comparative studies from other jurisdictions, which is comparative studies about custody. You shouldn't have those studies. That should be about child time, time with, overnights with, because at least those are standard. So Australia loves changing terminology. There's this parliamentary tendency to say the old words have become corrupted by fault and loss. So dads classically said, Mum's got custody and we got the consolation prize called access. So access has become associated with consolation prize. Let's abolish those terms and bring in new terms. So 2006, 1995, they brought in a whole bunch of terms. One of the judges in Brisbane says, Mr. Wade, is this a custody application or whatever it's called this week? So the complete disillusionment of the skilled helpers that we now have a fancy phrase which none of our clients use. Clients still call it custody. They're not quite sure what that means. They still talk about visitation dads or visitation mums. They still talk about access. And then when you draft your settlement, you have to convert their language into the current technical language. So look on page 7, the horrible language we ended up with in Australia in 2006 in the many transitions. Time is designated by lives with. So who is the lives with parent? Imagine how many people are talking about it on the street. Are you the lives with parent? I mean, it sort of becomes Monty Pythonish, this change of terminology. And what is the access parent called? The parent who spends time with. The lives with parent and the spends time with parent. And then what is guardianship? The old form of guardianship was the person who had the power, not the time, the power over the child. That's been moved to a horrible, politically correct phrase called equal shared parental responsibility. Are you the equal shared parental responsibility parent? I'm not sure. So notice the great difficulty now in doing cross-cultural comparisons given the terminological reforms and the parliamentarians' love of changing language to give people a fresh start. All right, so that's the context. You see some of those phrases there. All right, now we go back to context again. What were the patterns of decisions by parents? No, so I'm not saying by courts, because courts are marginal. Prior to the 2006 reform. These stats are fascinating and you need to ask Canadian researchers to try and do the same. Once you see these, you can give them to your clients and you can say, this is what other parents are doing. Where do you hope to fit? Where are you now? Okay. Pre-2006, 88% of children live with, this is on page 8, so make any notes, that is they spend the majority of overnights with their mother. Majority gets defined as 65% of overnights or more with the mother. Watch the next one. 32% of children never or rarely see their other parent, usually the father. So this is the kind of mythology of the deadbeat dad that exists in many jurisdictions, but that mythology is not helpful. Now this next one is a killer, everyone. The Canadians need this too. Canada's a big country, spread over a lot of borderland with the United States. Look in Australia, 26% of parents live more than 500 kilometres apart. It's an extremely important stat to be able to show to your clients that mobility is a normal part of modern industrialised societies and people looking for jobs. So no wonder there are a lot of relocation disputes. No wonder there are a lot of parents who never see their kids, because I live in Toronto, my kids live in Vancouver. I mean, I can see them for 2 weeks a year in the holidays. So this is the normal pattern of industrialised societies. Next, 6% have significant shared care. So notice the terminology in Australia gets nice definitions. So significant in this particular research. These are two great researchers. Richard Chisholm is a former family court judge, and Bruce Smith's a great social psychologist, works for AFES. And so notice more than 30% of overnights where families are saying we will have substantial or significant shared time. Only 6% of Australians have agreed to that. Remember, the courts are marginal. Courts don't matter, because this is all about what Australians are doing. So the big question, it's called pro-contact legislation, the 2006 legislation. Here it tends to be called equal time legislation. Very, very poor language, very unhelpful language in Canada, in my opinion. So now we go to courts. Pre-2006, what did the courts order? Page 9. Now here is where the research you must distinguish between court orders which are made pre-filing. So in other words, you have an agreement and you just hand it up to the court. That's one form of court order. Next, post-filing. The people are contested to start with. They may be contested for 6 months. They argue with one another. They don't get near a court except to file. But then they hand up what's called consent orders. In the United States called stipulations. You hand up. That's a different kind of court order. So you've got court order before filing, court order post-filing, and then full-blown hearings. Remembering this last statistical number is tiny. All right, so what happens pre-2006? Mothers, by consent orders, are getting residence, are getting the majority of overnights. Slight statistical distinction between we walk straight in and hand up our consent orders, and we file and then hand up our consent orders. If you go to trial, mothers get residence, so the phrase that in those days was residence, they become the live-with parent. In 69% of the few cases that were tried. Now be very careful, the meaning of few is probably 300 a year, maybe a bit more, so 30,000 separations involving kids a year, 300 full-blown hearings. Don't get too carried away with the courts. The courts are not where the action is at all. And here we have the going rate, 80-20. Pre-2006, the courts are using the bargaining model back in the courts. What will happen if you go to court? Oh, they tend to do 80-20, every second weekend and half the school holidays. That was the formula with all kinds of variations, but basically 20% of overnights for the non-residential person. Now, here we get nice breakdown, is if you want to be in the 300 who go to court, 300 families out of 30,000 families, here is the range for the non-resident parent. So how much is it worth fighting? If you go to a full trial, 70% of those trials end up with usually the dad, but the non-resident parent getting between 51 and 108 days. 108 is exactly on 20%. Remember, all these numbers are affected by the child support tables. Child support tables are affecting the time with discussion. Guess what happened at 108 days? The rate of child support dropped. So negotiations are conducted as a package. If the dad can get to 108 overnights, his rate of child support drops on the table. So that became a very trendy settlement spot. So do not think that these negotiations are conducted independently. Property, child support, and child time. They are conducted either expressly or impliedly overlapping. When some of the fathers' groups were told, you should go to court because you will get a better deal, these statistics are extremely helpful. The answer is, if you manage to get to court, if you're in the 300, which is very unlikely, yes, you will. If you get to a full-blown trial, you will get more time, if you manage to get there. That's if. There's a lot of ifs on the route, but the more time is not much. It's only relatively few overnights. So the next question. Oh, this is, everyone put a circle around this. Probable that every number varies soon after the agreement or order is made. Beware of Pyrrhic victories, lawyers. Beware of Pyrrhic victories, mums or dads. Kids vote with their feet. Life changes. So you fight for 2 years to get 108 overnights. 2 weeks later, the 13-year-old says, I ain't going to live with you. They walk out the door. So the rate of change of these arrangements is constant. And so these stats are wobbly, but also your advice as a lawyer has to be constantly modified by whatever you get is going to change. Whatever you get is going to change. So be careful of Pyrrhic victories. I did a relocation case. I was a mediator. And it was fascinating because the family had moved to Australia, and they moved from England to Australia, and for the dad, Australia was the promised land. There was less class distinction. There's still class distinctions in Australia, but less than. He was a carpenter. He got a great job building traditional houses. His 2 kids went to a great school. His kids were 14 and 10, 2 girls. And he was paid well, and he loved the sunshine. And so for him, Australia was paradise. For his wife, it was a wilderness. It was a cultural desert, and she hated the culture and hated the sun and the sunburn and everything about it. So they split up, came to mediation. She wanted to move back to England, take the kids with her, 14, 10. So long mediation, many tears, and eventually they cut the deal that the kids would go back. I interviewed the kids as a mediator. Not always do that, but did in this case. And the kids were effectively parenting the parents because they had these skills, especially the 14-year-old. And she said, I have to go back to England and support my mum. And so we drew up the agreement that she's going back with the kids and Skyping, and we had all these then qualifications on the absence from the dad. Guess what happened? So the mum won. Back to England. Guess what happened?
Kids went back to dad.
Because
They like the sun.
kids get to England, grey, boring, rains, no friends, mum's doing okay, don't like mum's friends. 14-year-old phones up dad and says, I'm coming home. What happens next? What happens next?
The other one.
Wanda got it. The 10-year-old says, well, I'm not going to stay here by myself. So the 2 of them get on a plane, fly back to dad, and guess who's left in England alone? Mum becomes depressed. She gets on a plane, comes back to Australia, and lives in the cultural wilderness, now trying to re-establish relationships with children who are pretty independent, who are sort of going their own way. So this is a very important qualification. How do you deal with the proposition that things will change? You're not negotiating about a win, you're negotiating about a short relationship, maybe a long relationship with the kids. Okay, so did the pro-contact legislation alter anything? So next, here is the great research again by Chisholm and Smith. What are the patterns? So you could hand this to a client. You could give this to a client. Say, these are the patterns. Remember, people are persuaded by normalcy. People are, it's normal. 71% of dentists use Colgate. It's normal to do this. All right, so traditional, a third of Australians. So remember, this is by census, so this is what is happening, not what is ordered. The courts, again, marginal. Little or no time. So 26% separate different parts of Australia or the world, emotionally distant, physically distant. Then you have some nice little aberrations, daytime only, maybe with toddlers, maybe with people under 2, under 3. Holiday only, very predictable. People have holidays only, they live in different places. They can't get holiday time, very predictable, convenient arrangement for some families. Occasional time, once every 3 to 6 months. Again, very predictable. And once again, substantial time, what does the census say? Where there is more than, in those days substantial was called 30%, it's now called 35%, 6%. So the so-called shared parenting times was still a very small minority. That's the context. Any questions about context? Here comes the reforms. Reforms. So the reforms came into effect because, this is a very short summary, this is my summary, though I think I share it with most of the reformers, is, and they should not be called fathers' rights groups. The word right is one of the boo and hurrah words which is so badly abused. It just could be called fathers' lobby groups. Do not use the word right. It just complicates the whole discussion to such an extent. At least that's my... Fathers have an interest, mothers have an interest, grandparents have an interest, society has an interest, the children have an interest, and you're trying to balance interests. The right word is a very important word when you have had atrocity, when you want to create rights for children not to work in factories, when you want to create rights after Bosnia, or, but it's a problematic word because a right suggests that it trumps another interest. And so fathers' rights, by definition, is a false statement. It clearly, fathers' interests do not trump. They are interest in the mix. So fathers' interest groups lobbied a liberal government. That's the name of the party that was in power. And the liberal government had shaky hold on power. So this very organised fathers' interest groups. Mothers' interest groups were very disorganised, chaotic, couldn't make the same noise. And same with children. Children always underrepresented and no power in the lobby area. So these fathers groups said, we want more contact. So it became the pro-contact movement, and they pushed for a presumption of equal time. And the government, and I'm very cynical here, the government went with this because it was cheap, didn't cost them anything. They just changed the words in legislation, and allegedly, remember, zero cost. So it's extremely attractive for politicians to buy some of the organised lobby groups with a cheap reform, which has serious consequences, but they don't worry about that because they'll be out of office by the time the consequences come into play. So they buy the votes and they're given the assurance that they will get fathers' lobby group votes. Same thing happened with the gun lobby in Australia. So in comes these amendments to the Family Law Act, and here were the 3 key sections. Notice in the cutting and pasting that the word presumption started to be modified by must consider. It's a softer version of presumption. So the court, if you get to court, must apply presumption of equal control over power. Power, which school, which church, which medical operation, which passport, which international travel. So presumption of equal power if you get to court. Before you get to court, there's no presumption of equal power. Each parent can make their own decisions without having to consult the other person. And then as far as time, so this is a power section. These 2 are time sections. So the courts instructed that they must consider equal time and they must consider substantial time. Substantial time is not defined well in the Act, but child support legislation, that's the money legislation, call substantial 35% of overnights or more. Okay. All right, so that those particular amendments caused the usual confusion. What does this mean? What are the consequences? So let's jump to page 13. Immediately was the question, what are the consequences? We'll get through. Okay, on the Family Law Council, we were bombarded with anecdotal effects. And so there was a document that we prepared, 24 anecdotal effects of this legislation. Anecdotal effect number 2, confusion for gossip law, confusion for law of the office law. Confusion, what the heck does this mean? People looking for advice but not being able to get clear advice. Number 10, anecdotally, a new breed of relocation disputes broke out. I don't want the child moving across town because that's inconvenient when I want to spend more time with them. Number 14, a lot of money spent trying to re-educate fathers particularly that must consider does not mean equal time. Must consider does not, but they'd say, but this is what the legislation said. So an education industry sprang up in the local councils, in the local mediation centres. Number 17, very important, the hidden monster of family violence became visible. People began to allege violence, which presumably had always been there, because this was the way of rebutting must consider. Don't have to consider equal time where there's been violence. So suddenly, Australia turned into a violent society visibly. Allegations of violence were the normal strategic response. If you want to have a negotiation lever to stop this being must consider equal time, must consider substantial time, you better give me some evidence of violence. All right, so then that's the anecdote, then the research. A number of young children were killed, nothing killed by dads. They could have been killed by mums, but they were killed by dads. And so the newspapers put a lot of sensationalist articles about the lawyers are to blame, the judges are to blame, and the Attorney General's to blame for implementing this legislation, as though the legislation had caused the death of the children. Now, if these dads who were mentally ill had wanted to kill the children, they'll kill the children no matter what the legislation says. So it was very unfair attribution, blame the lawyers, blame the judges, and then blame the political parties who brought this into play. But nevertheless, sensationalism causes reform, not statistics, not truth. So they commissioned this study, 28,000 people interviewed. It was potentially embarrassing research because it could say the government made a big mistake. And so this is what the research showed. And these statistics are very important to reflect upon. So this is page 17. Of the 100% of separating parents, this is separating parents with kids. Remember, half the parents who separate don't have kids. 20% resolve using helpers. So this is quite devastating for the legal profession. Devastating for me. I thought I was the center of the universe. I discovered I'm absolutely marginal. 20% of the population use skilled helpers. What do the rest do? Oh, we kind of muddle through. 80% do not. Oh, no. But aren't mediators important? Aren't counsellors important? Aren't lawyers important? 6% of the 20% went to lawyers, 3% went to courts, 7% went to counselling mediation and these family dispute resolution centres, these ones that have been set up, and 3% went somewhere else, maybe to a local parish minister, maybe to a next door neighbour, who knows, they went to somewhere else. Notice the important qualification at the bottom though. 1/2 of the do-it-yourself parents, this is the 80%, made 1.8 visits to some skilled helping centre. Might have been online, might have been a drop-in centre. So the do-it-yourself people are getting information from somewhere. They're not completely in gossip law. They're in gossip law, plus I visited this local centre twice and asked questions. Now, you need to come back to this many times, all right, many times. The other stat attached to this is 75% of separating parents have reached an agreement within 1 year. Very important. That means 25% have not. 75% of separating parents reach some sort of agreement within 1 year. Notice how the courts are just not featuring in this. The courts are marginal, as many studies show. Okay, next important stat. Watch this. Notice very important qualification. This is on page 17 as self-reported. Put a big circle around that. This is not as studied by an outside observer. This is as the people being interviewed said, is your husband violent? Is your wife violent? Tick, tick, tick. So there's self-reporting. 80% of Australians separating with children say one or both of them is violent, abusive, substance addicted, that's drugs or alcohol, or mentally ill. 80% of people self-report. So what's going on here? Is this an indication of modern society? Or is this what the lawyers right next to it, this called the temporary insanity of marital separation? Very, very important. Once you're in practice, you'll hear lawyers saying all the time, oh, my client's temporarily insane. Don't worry, they'll get over it. That's the law office advice. Yes, your husband's crazy. Yes, your wife's crazy, but don't worry. Once we settle this, it'll all settle out. So that's the law of the law office. But watch what happens for the stats. This is incredibly helpful and also devastating. 20% are not. They don't self-report one of these features. Watch this. Future outcomes. As we separated, we said this. Look, 20% again are distant. So you need to show this graph in Australia to your clients. 20% of the separating couples will probably not talk much ever again. They'll be living in separate cities. They'll carry on their lives. They'll have new families. There won't be much caring across. So that's a statistic. That's 1 in 5 separating couples. Next. This is the bad one. 20% are living in long-term, high conflict situations. Either high conflict because of the dynamics, or high conflict because of substance abuse, because of cocaine use, all that kind of thing, or mental illness. So this is a big problem. That's 1 in 5 families are in long-term high conflict. Put a big circle around that. The research is unanimous. Kids should not be shuttled. Kids should not be shuttled in high conflict families. That's just, no one disagrees with that. That's an absolute. So if you have a presumption of shared parenting, that presumption is damaging to 20% of the kids in the nation who are in separated families. Next. This is very encouraging. 60% of separating parents said, oh, it was hell, we went through hell, but we're doing okay now. We talk to one another. So here is where the street law or the law of the office law is correct. Notice you can say to your clients, which lawyers I work with for years say, I know it's bad now, but don't worry, once it's settled, everything will settle down. So they were half right. It will settle down. The temporary insanity of separation for 60% of separating parents will turn into, oh, we're kind of doing either very well or we're muddling along. Okay? An environment which a child does not have to manage, does not have to lie about, does not have to bear the stress for. But here, we've got a problem. Now, just right next to this, why should the law say presumption of equal time when presumption of equal time is irrelevant to 20% because they live in other parts of the cities, of the world, is damaging for 20%, and 60% take no notice of it because they agree to what they want to agree to. Right? So why should there'd be a presumption of equal time when it's damaging to 20%, irrelevant to 20%, and the others agree to what they want to agree to. It's a very strange attempt of the law to be way ahead of social behaviour. Okay, any questions at this stage? It's all very yeah, this is either overwhelming you with data. So you can get where I'm going to pretty fast here, can't you? Is these reforms are at least inappropriate and at least damaging for a substantial proportion of the separating parents in Australia. And we'll talk about how that happens. Okay, so notice approximate percentages because different parts of the studies in different areas of Australia led to different numbers. So how much change? 33% of children spend 100% of overnights with mum. So the maternal preference is still there. 33% live predominantly with mum, with the dad underneath substantial time. Still shared time. So we've got 66% straight off still living with mum, residential parents. Okay, this is after the reform, 3 years measuring after the reform. 9% live with fathers, plus either no visits up to 34% with mums. Now this is the important one, this is where things changed. Between 16 and 25%, depends which part of the study you read, children are in shared care. The meaning of shared here is substantially shared. So 35% or above in one household and in the other household the residue. This is the most substantial change after the reforms. Query, was it caused by the reforms? Probably yes, to some extent. So the number of substantially shared households has increased by maybe 10%, maybe as high as 19%, depending on which study you look at. So substantial care has increased. Was it caused by the reforms? And the answer has to be in part. You'll see in a moment, in part, yes. Only 7% of this group are in equal time. Notice, not by court orders. Not by court orders. They're in equal time because of agreement. So when you look at the court orders made at that time, there's 1 or 2 or 3 or 4 equal time. Australian judges have almost reversed the presumption. If you come to court, that is indication that you cannot cooperate and communicate, therefore you are not competent to have substantial or shared time. They've reversed it as a matter of judicial practice, because what's the point of ordering substantially shared time when you have demonstrated you're unable to cooperate? Note the changing nature of the snapshot because, and note maternal dominance once again, because in this group, probably 2/3 will be predominant time with mum. So 33 plus 33, or up to 66, plus probably another 10. You're close to 80% mothers are still the majority of overnights. Now this is important because I see a lack of discussion of this in Canada. So this is once again just observing statistics. If there is shared time, if there is substantially shared time, how is it reorganised according to age? Watch. Only 8% of people with shared time have kids under 3. 20, 26, 20, teenage years, the teenagers vote with their feet. I'm not going to stay in shared time, you guys. I'm going to go back to some other arrangement. So notice the nice curve here. You have a discussion then is, are the patterns, this is all on page 18, are the patterns being used by parents reflective of good practice, good parenting practice? Do we go, what parents do, the is indicates the ought. Is that what we should do here? How far does these patterns overlap with child psychologists talking about appropriate age stages. 2 minutes, okay. Okay, what harms? Here are the harms, page 19. Children will be harmed no matter what is the law, the gossip law, the law of the law office. Children will be harmed. This is on page 19. So it's don't blame the reforms for the evidence of harmed children. They may have contributed, but children in any system where there's separation will be confronted with the 20% of the population of adults who are mentally ill, addicted, high conflict. So in Australia, at least 200,000, there are at least 200,000 incompetent separated parents who would be called incompetent. They're in the 20% because of mental illness, because of high conflict dynamics. That is probably a given, a standard. It's going to stay there. Some stats from this say it's much higher than 20%, but I'm giving you a very conservative number there. So that's a reality of life. You're not going to change the parents. That's how they are. So the question is, how do you keep children away from that group of parents as much as possible, or reduce the time with the mentally ill, or reduce the shuttle when there is high conflict? So there are many beneficial reforms for children, page 20. And so we shouldn't overlook those. The position of parents in modern Western children in modern Western industrialized societies has improved dramatically because of education, medical benefits. So don't look at this in a downside. Just say that there is this group who are in strife. So the 2006 reforms moved more, here's the weasel word, more children into the damage zones. That's the conclusion of all researchers. More children got into shuttle with that 20% of high conflict parents. More children got into substantial time with a mentally ill, personality problem parent. So did they affect it? Yes. How, to what extent? Hard to say, but definitely affected. Therefore, conclusion, the reforms were a mistake. How do they predominantly affect it? Because of gossip law, not because what the courts did. The gossip law is around. The settlement law moved from 80-20 to 70-30, therefore moved children by settlement into the danger zones, not because of the courts. Now the courts were also making orders that moved from 80-20 to 70-30, but statistically they're a tiny group of people. But gossip law most definitely was saying, the going rate's 50-50, dads, you get 50-50, but if you get a deal on child support, go back to 70-30. So the negotiation was clear, start with 50-50 and drop back. Some bad news for lawyers. For 2 years, the judges who were making interim decisions, people rushing in seeking interim orders, said this legislation must mean something. I don't know what it means, but it must mean something. So in interim orders, there is very little evidence. In Australia, 2-hour hearing, 2 affidavits, no cross-examination, no oral evidence. So this is rough justice. You need to get through these interim hearings. So some judges began to make orders that the dad, it was often dads, have contact with a child when they had not had much contact with a child during the marriage, because they said this legislation must mean something. And that encouraged the gossip law that 70-30 is the going rate at interim hearings. But judges retreated after this murder of a number of children. The newspaper said judge's fault. It wasn't the judge's fault. But the judges became extremely nervous about having their names on the front pages of newspapers and began to seek for more research on what are our options when there is some evidence that this family is highly conflicted or some evidence of mental illness. So don't blame the law, blame gossip law, blame the settlement law, and blame for a while the interim hearings. The legislation had that side effect on gossip law, confusion in the profession. Now if you're a judge in Australia, you have in the few cases you hear, you have this tension. You know what the research says, we're moving too many people into the danger zone. How do I keep more kids out of the danger zone? And it's very tough being a judge. So I've given you an exercise on page 24. The repeal, will this be changed in Australia? Here's the depressing, no political will, no votes in repeal. You can give, hard to take back. You can give. The motivation for reform is going to occur with dead children, unfortunately, and it won't be the truth that will be leading to reform. It won't be these studies, it'll be sensationalism and votes. But if you reform, what law must or could replace? Whatever it is, it must be in simple language. It would go back to the best interest test, maybe. And gossip law, you'd have to work a lot on gossip law to say this is no longer the law. One prediction, which I don't see in Canada, is that child development tables, which some judges use in Australia, page 33 onwards, you've got an example of it, that perhaps these will be legislated into effect to say judges and gossip law should look at child development tables. The main thing that would happen there is you would never, ever have equal time or substantial shared time for children under 2.5 years. Never. The judge would go berserk and say, you do not shuttle a toddler or a baby. Child development principles are pretty clear on that. Okay, that's it.